A judge scorns a black woman in court, unaware. She's the new Chief Justice of the Supreme Court. Picture a packed courtroom in the heart of Washington, D.C., where the heat of simmering tensions collides with the chill of polished marble columns. A senior judge, renowned but feared, holds the gavel in a clenched fist. His reputation precedes him. Efficient but ruthless, old-fashioned to his marrow, and not inclined to check his own prejudices. Today, a woman stands before him, graceful yet unassuming, wearing a simple charcoal grey suit. She's African-American, composed and resolute, yet there's a flicker of pain in her eyes as the judge unleashes his rebuke. He doesn't care about her credentials or her story. In fact, he barely looks at her. To him, she's just another face he believes to be unworthy of the court's respect. But this judge is about to receive the shock of his career. The woman he's publicly belittling is none other than America's newly confirmed Chief Justice of the Supreme Court. The morning sun was creeping over the skyline, painting Washington, D.C. in burnished gold. The city was bustling with the kind of energy that only the nation's capital can muster. Deep in the heart of the city stood the E. Barrett Prettyman U.S. Courthouse, its classical facade adorned with tall columns. Legal clerks hustled in and out, carrying heavy case files and laptops. Journalists lingered around the entrance, hoping for a scoop on any high-profile hearing. But amid the swirl of purposeful movement, very few noticed the arrival of an elegant figure stepping from a modest black sedan. A middle-aged black woman, tall and poised, emerged, pausing a moment to gaze up at the building before her. She was wearing a conservative suit, charcoal grey with a crisp white blouse, her hair styled into smooth professional waves. A pair of black leather pumps complemented her subdued look. She carried nothing but a slim folio, inside which were a few personal notes. Her name was Justice Althea Sinclair, and unknown to most in that crowd, she had recently been appointed the Chief Justice of the United States Supreme Court. Traditionally, a new Chief Justice's first days are marked with formalities, handshakes with various heads of department, and internal court adjustments. Yet Althea had chosen to spend her first morning away from the Supreme Court building. She had come to the Prettyman Courthouse to observe a case that had piqued her interest for quite some time, one dealing with voter suppression allegations in a small county in Georgia. It was a cause she'd devoted her early career to, and she had long wanted to see how the judicial system now handled such claims. On the sidewalk, a clerk gave her a sideways glance, perhaps assuming she might be a defense attorney or a potential witness. She returned the clerk's polite nod, revealing a slight but genuine smile. Quietly, she made her way inside, not announcing her presence. She had no entourage, no cameras trailing her, just a personal desire to witness justice unfold. Inside the courthouse, she checked the docket for the morning. Courtroom 6B, Judge Ronald B. Patterson presiding. Patterson, an older man with a reputation for strict courtroom management, had served the district for over 30 years. Althea knew him only by his name and some general commentary about his style. She'd never argued in front of him herself, nor had she met him socially or professionally. The moment she heard from a colleague that he was assigned to this voter suppression case, she felt compelled to attend. This was, after all, one of her earliest passions, ensuring that every American, regardless of background, had the unencumbered right to vote. Walking up the marble steps and along the wide corridors, she inhaled the hushed air of legal proceeding, a blend of slight anxiety, formality, and the unspoken promise of justice. She passed several large portraits of revered judges who had once presided here. Their solemn faces seemed to watch over every visitor. It reminded her of her own journey. A once little girl from Atlanta, raised by parents who worked tirelessly to ensure she got the education they themselves never had. Althea reached the large wooden doors of 6B. She gently pushed them open and slipped inside just as the session was about to begin. The courtroom was half empty. A scattering of people filled the public benches, some reporters, some relatives of the plaintiffs, a few law students eager to learn. At the front, the plaintiff's counsel sat behind a neat row of files, conferring with her client, while the defendant's team glowered from the opposite table. Althea chose a seat in the back row. She quietly observed the flurry of last-minute adjustments, the arrangement of legal documents, the adjusting of ties, and the hushed instructions from lawyers to clients. The overhead fluorescent lights buzzed softly. Before she even saw him, she heard the clerk's firm call to order. "All rise for the Honorable Judge Ronald B. Patterson." The hush that fell over the courtroom was profound. Patterson entered in his black robe, his silver hair meticulously combed to the side, his wrinkled brow set in a permanent scowl. He carried the air of a man who believed in absolute discipline, someone who had worn the gavel like a second skin for decades. The clerk continued with the formalities, and everyone sat down. Althea found her heart beating a bit faster. She wasn't sure why. Perhaps it was the old nerves from her days as a public defender, or maybe the ghosts of her own battles against voter disenfranchisement. But mostly she felt a twinge of excitement to witness justice at work in the place she had once yearned to stand. Little did she know that by day's end, her memory of that quiet seat in the back of 6B would become an important story in legal circles for years to come. Judge Ronald Patterson was somewhat legendary among the old guard of the legal community. In his early years, he had been known as a methodical judge, stern yet fair. Over time, however, he became increasingly archaic in his methods. He often questioned progressive legal concepts with barely veiled skepticism. Lawyers who championed civil rights cases described him as a tough nut, meaning that persuading him on certain matters was next to impossible unless the law was overwhelmingly clear. The bailiff called for order, and Patterson settled into his high-backed leather chair. A moment of silence passed as he surveyed the attorneys before him. His gaze was heavy, as though searching for signs of weakness or potential defiance. Althea could almost feel him measuring the room, deciding how far to push that day's proceedings. "Counsel for the plaintiff, are you ready to proceed?" he asked, his voice carrying a hint of condescension. A short, bespectacled woman stood up. Her voice was steady, yet uncertain, as if aware of the challenge she was up against. "Yes, Your Honor. My client is prepared to present evidence that demonstrates—" Judge Patterson cut her off with a raised hand. "I've read the briefs, counsel. You're contending systematic voter suppression in Appling County, Georgia, correct?" "Yes, Your Honor," she responded. "We have evidence that certain precincts in predominantly black neighborhoods were understaffed and under-resourced, leading to hours-long lines and the—" "Once again," Patterson interjected, "I've read the briefs. That's enough restating the obvious. If your evidence is so compelling, I suggest we get to it. We don't need the entire backstory from you." "Understood?" The attorney nodded meekly, her cheeks flushing. Althea felt a pang of empathy. She remembered what it was like to stand before a seemingly hostile judge. Patterson's manner was blunt. At times, he practically ordered counsel to skip introductions, moving into arguments. Althea quietly took notes on how the judge handled the hearing. The atmosphere was tense, but she respected the fact that the law often demanded brevity in the face of heavy dockets. The plaintiff's legal team called their first witness, an elderly poll worker from the county. He recounted how he'd been directed to hand out fewer ballots than necessary due to budget cuts and to close the station early, claiming unforeseen circumstances. When pressed for details, the witness revealed that the instructions had come from local election officials who told him to keep things orderly. Patterson listened with an air of disinterest, occasionally yawning or glancing at the clock. Althea narrowed her eyes. She saw the subtle facial gestures Patterson made when key evidence was presented, like tiny dismissals. It was as if he'd already decided the matter. She'd encountered judges like that before in her career. Some believed allegations of voter suppression were overblown, that times had changed, and that any shortfalls in polling sites were simply logistical errors, not systematic wrongdoing. At one point, the plaintiff's counsel objected to the line of questioning from the defendant's side. Patterson, rolling his eyes, said, "Overruled. Let's keep this moving, Ms. Carter." He spat out her name with something close to contempt. From behind the rail, Althea had an uneasy feeling. He's not even pretending to be neutral, she thought, tapping her pen lightly against her notebook. Could it be that Patterson simply had a no-nonsense style of pushing cases along, or was his impatience a symptom of a deeper prejudice? During a brief recess, the attorneys filed out, leaving Althea among the few still seated. Patterson began rummaging through some paperwork on the bench. Her seat was near the back, and his gaze had yet to land on her. She considered introducing herself, but she hesitated, preferring to keep a low profile until the hearing concluded. She wanted to observe him fairly, without the dynamic changing the moment he realized who she was. When the short recess ended, everyone resumed their positions. The next witness was a civil rights activist who had monitored the polling stations and even documented some incidents on her phone. She began describing how lines in black neighborhoods stretched around the block, while lines in predominantly white neighborhoods moved quickly. The disparity seemed glaring. Patterson, however, showed little interest in the activist's testimony, frequently shuffling through documents and interrupting with pointed questions that undermined the significance of her story. Althea felt her stomach tighten. Despite her desire to remain impartial, she could not help the flicker of anger inside her. This was precisely the kind of subtle discrimination she'd fought against for decades. The casual dismissal of marginalized voices, the rhetorical belittling of their experiences. She took more notes, highlighting key moments where Patterson seemed to have decided the witness was unreliable without genuine cause. By noon, Patterson declared another recess, this time for lunch. The plaintiff's witnesses were still only halfway through their list, and the defense had yet to call anyone. Althea watched as the tension hung in the air. She expected Patterson to remain stoic, but as the bailiff asked all to rise, she caught an almost imperceptible smirk on the judge's face as he retreated from the bench. She felt a pang in her chest. Was this the kind of justice system she was now overseeing as Chief Justice, where some judges still carried the biases of eras past? She breathed in and out, reminding herself that the path to fairness was often fraught with these challenges. She rose to gather her things and follow the rest out for lunch, her mind racing with the tension between her duty to remain a neutral arbiter of the law and her moral responsibility to ensure that justice was served. Althea found herself in the courthouse cafeteria, a place that felt almost too ordinary for the gravity of the proceedings going on upstairs. The walls were stark white, the tables laminate. Federal employees, lawyers, and visitors all jostled in line for the daily special or a simple sandwich. She opted for a salad and iced tea, then searched for a quiet corner. She sat down, only to find her mind swirling with questions. Should she reveal her identity now, possibly injecting a sense of caution into the judge's conduct, or should she continue quietly observing? Her official oath obliged her to protect the integrity of the judiciary. But she also knew that springing her title on Patterson in the middle of the hearing could overshadow the case itself, turning the focus away from the actual legal issues. A bright voice interrupted her thoughts. "Excuse me, is this seat taken?" Althea looked up to see a young law clerk, perhaps in her mid-20s, smiling politely. Althea shook her head. "No, please sit." The young woman placed her tray down and offered a kind grin. "I'm Anna, a clerk with the district court. You're new around here, right? I haven't seen you before." Althea smiled in return. "I'm just visiting to observe a case." "Good to meet you, Anna." Anna nodded. "Oh, you're in 6B too, I bet. The big voter suppression trial. Everyone's been talking about it. Judge Patterson, well, let's just say he's got a unique style." Althea hummed in polite agreement. "He does seem rather direct." Anna let out a soft sigh. "Yeah, direct. That's one word for it. But I guess it's better than some judges who just go on tangents." She glanced around to ensure no one was eavesdropping, then lowered her voice. "Though between you and me, I've heard some folks say he's not always so objective when it comes to race-related cases." She paused, as if worried she'd said too much. Althea gave her a gentle nod of understanding. "I've heard similar observations." Anna tapped her fork nervously against her tray. I'm only a few months into my clerkship, but I can already sense how certain predispositions can influence decisions. It's frustrating because the system is supposed to be fair. It's supposed to be about the law, not personal biases. Althea felt a flicker of admiration for Anna's honesty. The younger generation of legal professionals often had fewer qualms about naming injustices. It's good that you're aware, Althea replied softly. You have a chance to help shape the future of the law, no matter how small your role might seem now. After a brief, companionable silence, Anna ventured, So, do you practice locally or? Althea hesitated. She decided not to reveal her position just yet. I'm based in D.C. I work on a few legal matters here and there. It wasn't a lie, but it also wasn't the whole truth. Anna studied her with a hint of curiosity, but didn't press further. They continued making small talk about the proceedings, the general environment at the courthouse, and the complexities of civil rights litigation. As they finished lunch, Althea felt a glimmer of hope. If more individuals like Anna populated the judicial system, maybe the justice Patterson was dispensing today would be a relic in the future. They parted ways in the corridor. Althea ascended the stairs to 6B again, still pondering. Her mind drifted to the vast responsibility she held. As Chief Justice, she wasn't just an observer or a silent figurehead. She was a guardian of the Constitution, an overseer of the federal judiciary's integrity. The question was how best to guard it. When the court reconvened after lunch, the tension only increased. The plaintiff's legal team resumed calling witnesses, each detailing their own experiences at the polls. Stories of ballots running out, machines mysteriously malfunctioning in minority neighborhoods, and poll workers refusing to offer provisional ballots stirred anger among the audience. Judge Patterson began looking annoyed, glancing at the clock on the wall, tapping his fingers on the bench. He started cutting off lines of questioning that he deemed repetitive. The plaintiff's counsel tried to protest, pointing out that each witness had unique testimony, but Patterson was unswayed. Before the last witness took the stand, the judge suddenly addressed the gallery. "Let me be clear," he said, tone dripping with impatience. "I do not intend to waste the court's time entertaining redundant testimonies. If counsel cannot provide fresh material, we'll move directly to the defense. I will not allow this proceeding to spiral into a circus." His gaze then swept around the room until, for a split second, it landed on Althea. She felt a jolt. She expected him to move on, but his stare lingered, as though something about her presence offended him. Or perhaps he simply wondered who she was and why she was taking notes. His brow furrowed. The moment, though fleeting, felt electric. She met his gaze calmly, refusing to shift. If he wanted to intimidate her, he'd have to do better than that. After a second, he tore his eyes away and nodded curtly to the plaintiff's counsel to continue. The final witness was a local pastor who had escorted elderly churchgoers to the polls on election day. He described how lines in his precinct meandered through the parking lot and down the street. Many seniors, some in wheelchairs, others requiring canes, had to wait hours in the hot sun, with no seating, water, or assistance. By the time some reached the front, they were told the polling place had run out of ballots. Patterson exhaled loudly, cutting off the testimony. "Pastor, I think we've heard enough about long lines. That alone does not prove intentional suppression. Let's get to the heart of the matter. Did anyone instruct you or your congregation members that you were prohibited from voting due to race?" The pastor, taken aback, answered, "Well, no, Your Honor, but—" Patterson didn't let him finish. "Right. Then let's remember that incompetence or mismanagement is not the same as suppression. Counsel, do you have anything else that points to a deliberate, coordinated scheme of racial discrimination?" The plaintiff's counsel looked flustered. "Your Honor, as we've laid out, the pattern of resource allocation, combined with the demographic makeup—" He waved her off. "Again, that's in your brief. I want direct evidence, not inferences or speculation." Althea's jaw tightened. Patterson was dismissing the concept of disparate impact, where policies or actions have discriminatory effects, even if not overtly stated. This was a long-standing principle in civil rights law, recognized by numerous Supreme Court precedents. Patterson was effectively demanding a smoking gun, a direct statement of racist intent, which rarely existed in modern times. His approach ignored the more subtle manifestations of institutional bias. When the plaintiff's side finally finished, Patterson seemed all too eager to turn the microphone to the defense. The defense counsel walked to the podium with a cool, rehearsed confidence. He argued that any issues on Election Day were due to logistical failures and last-minute budget cuts. He downplayed the shortage of ballots and the disproportionate effect on black neighborhoods, pointing to unforeseeable circumstances like weather and staff illness. Patterson nodded sympathetically at several points. As the defense spoke, Althea could see how carefully they avoided any direct mention of race. Their arguments were all about administrative backlog and capacity constraints. Althea's frustration grew. This was exactly how modern voter suppression thrived, cloaked in bureaucracy and plausible deniability. When the defense wrapped up, Patterson made a few notes. Then, adopting a paternalistic tone, he said, "Given the weakness of the plaintiff's evidence and the absence of any direct instruction to disenfranchise black voters, I'm inclined to rule." He paused dramatically, letting the tension mount. The plaintiff's counsel jumped up. "Your Honor, we request an opportunity for rebuttal." Patterson glared. "The court has indulged your witnesses for hours. Unless you have something unequivocally new to present, we have enough to decide. Do you have a single piece of undisclosed, unambiguous evidence?" The counsel hesitated. Althea could see the heartbreak on her face. She wanted to speak about the broader context, the pattern of discrimination, the reams of data that proved the correlation between precinct resources and race. But Patterson's approach made it clear, data and context meant little without a big gotcha piece of evidence. "I suppose not, Your Honor," the counsel conceded, deflating visibly. Patterson nodded. "Then it's settled. I will deliberate on this matter briefly, but my inclination is to grant summary judgment in favor of the defendants. Court is adjourned." He banged his gavel sharply, the sound echoing like a thunderclap. A murmur spread through the gallery. The pastor shook his head in dismay. The activist stared at her feet. The plaintiff's attorney exchanged distraught looks with her team. Patterson stood about to exit. But then, with an air of finality, he turned to the bailiff and pointed at Althea in the back row. "You," he barked, "the woman with the notepad. Come here." Althea froze for an instant, a hush washing over the courtroom. She glanced around, realizing he was addressing her. The bailiff looked uncertain, but motioned for her to approach. Althea rose slowly, walked down the aisle, and stood near the counsel tables, her eyes level with Patterson's. He squinted. "I've noticed you scribbling away back there. Are you a reporter?" Althea's heart pounded. This was not how she'd imagined revealing herself. She took a breath, her voice calm. "No, Your Honor. I am merely observing." His lips curved into a contemptuous half-smile. "Observing, huh? Well, in my courtroom, if you're not counsel, a party or press, you'd best have a reason to be here. So tell me, what exactly do you think you're doing?" An uneasy murmur rose among the few people still seated. Althea heard the shuffling of papers behind her. The plaintiff's counsel looked on with a blend of curiosity and dread. "I'm here to educate myself on the current state of proceedings in federal court," Althea said with composure. "It's important to me." Patterson huffed. "Oh, self-education. Well, I have half a mind to charge you for loitering, but that's not exactly a federal offense. Next time, I suggest you read the local rules about note-taking in the gallery." Court dismissed. He turned to leave, but something made him pause. Perhaps it was Althea's unwavering expression or a subtle flicker in her eyes that said she wasn't just a curious onlooker. He frowned, then scoffed. "Look at you, so sure of yourself." Got a nice suit on, a fancy little notepad. In my 30 years, I've seen more charlatans and troublemakers than I can count, pushing their agendas in courts they have no business in. He pivoted fully, raising his voice so everyone could hear. Let me give you some free advice. If you want to prance around like you own the place, at least be honest about who you are. If you were a real attorney, you'd know to show respect in my courtroom. A hush fell. Althea studied him quietly for a moment. Then she responded in a tone that was both gentle and firm. Your Honor, I am not a charlatan. As for respect, I have the utmost respect for the rule of law. With that, Patterson sniffed in disdain and stormed off the bench, leaving behind a charged silence. Althea's gaze swept the room. Several onlookers stared at her in shock. The bailiff offered an apologetic shrug, while the plaintiff's attorney looked as though she wanted to approach Althea, but thought better of it. Clutching her notepad, Althea retreated from the courtroom, her thoughts swirling. She had never personally experienced such blatant condescension in a courtroom. But more than the personal slight, she was disturbed by the possibility that Patterson's biases might be deciding the fate of hundreds of litigants, especially those fighting for civil rights. As she walked out into the hallway, she knew that by day's end, Patterson would indeed discover exactly who he had reprimanded, and the repercussions of that discovery would test the foundations of this courthouse's culture, and possibly shake up the entire federal judicial system. The next morning, Washington's legal community buzzed with an undercurrent of rumors. A certain witness, well, more like a mysterious observer, had been called out by Judge Patterson at the end of a high-profile voter suppression case. Word spread through text messages, emails, even a couple of quick mentions on legal blogs. People whispered that Patterson had publicly berated an unfamiliar black woman who'd been taking notes in the back. That might have been just another footnote in the life of the courthouse until an official clerk's note circulated among the administrative staff. It confirmed that the newly appointed Chief Justice of the Supreme Court, the Honorable Althea Sinclair, had been in attendance at the Prettyman building on the day in question. The dawn of realization broke like wildfire. Stunned clerks connected the dots. The woman Patterson had shamed? The one he nearly threw out of the courtroom for loitering? That had to be Chief Justice Sinclair. An undercurrent of scandalous excitement seized the courthouse. Some staff members were horrified, imagining the professional catastrophe this could spark. Others seemed grimly pleased, believing Patterson finally deserved a reckoning. Althea, meanwhile, arrived at the Supreme Court building that morning, her mind still replaying the events of the previous day. She had not publicized what happened. It wasn't in her nature to cry foul. But word travels fast in Washington, especially about something as sensational as a senior district judge scolding the Chief Justice. By the time she set foot into her new chambers, her secretary, Ms. De Leon, was already flushed with worry. "Justice Sinclair, Mrs. De Leon said, hurrying to meet her. "Good morning. There have been calls, a lot of them, from the press, from the Prettyman administration, from your colleagues on the Supreme Court. They want to know your comment about yesterday's incident." Althea sighed and set her purse aside. "There's nothing to comment on. It's an internal matter of the judiciary. I'm not out to embarrass Judge Patterson. Let's just say the rumor mill is overreacting." Ms. De Leon nodded reluctantly. "Understood, Chief Justice." But the Washington Post has already published a blurb in their morning legal roundup, mentioning a possible confrontation. They're asking for an official statement. Althea considered. "Craft a response. Keep it short. The Chief Justice visited the Prettyman courthouse in a personal capacity to observe a public hearing, and we have no further comment at this time. That's all." "Yes, Chief Justice." Ms. De Leon quickly scribbled notes to draft the statement. Before Althea could settle in, her phone rang. It was one of her Supreme Court colleagues, Justice Gregory Markham. He was known for his easygoing manner and had shown her unwavering support during her appointment. "Althea," he began gently, "I just got word about yesterday's fiasco with Patterson. Are you all right?" Althea pressed the phone close to her ear. I'm fine, Greg. Thank you for asking. Patterson had no idea who I was, and I didn't think it appropriate to announce myself then. You do realize this is all over the legal news now? She paused. I suspected it would be, but it's more important to focus on the fact that the plaintiffs in that case might not get a fair hearing. Patterson was practically dismissing them out of hand. Justice Markham sighed. Yes, well, that's a separate issue. Patterson is famous, or infamous, for ignoring subtle discrimination claims unless they're spelled out in neon letters. But we can't micromanage every district judge. You know that. Althea's voice was firm. I'm aware. I'm not trying to step on separation of powers' toes. But as Chief Justice, I also have a responsibility to protect the integrity of the judiciary. If a judge has displayed overt bias, that's a serious concern. They talked a bit more, each acknowledging the difficulty of the situation. Althea was new to her leadership role, but she was no stranger to adversity. Part of her wanted to let Patterson's slight go, chalking it up to a single man's arrogance. Another part, however, believed this moment might be an opportunity to address something bigger than personal insults. When she hung up, Ms. DeLeon handed her a stack of messages. Lots of folks want to schedule a time to talk to you, Chief Justice, and you've got a meeting with the Administrative Office of the U.S. Courts in an hour. They might bring up this Patterson situation. Althea nodded resolutely. Let them bring it up. Over at the Prettyman Courthouse, Judge Ronald Patterson sat in his chambers, flipping through the day's mail. He had a routine: coffee, half a bagel, scanning the front page of the Washington Post, and then dealing with law clerks' memos. That morning, he was in for a surprise. His secretary knocked gently, stepping inside with a worried expression. "Judge," she began, voice trembling slightly. "We're getting a lot of inquiries about yesterday's session. The press wants to confirm if you confronted Chief Justice Sinclair in open court." Patterson's eyebrows shot up. "Chief Justice Sinclair? Are you telling me the woman I spoke to, the one with the notepad, that was—" His secretary nodded, wincing as if bracing for impact. "Yes, sir. It appears she was there, quietly observing. Some of the staff recognized her. We, have multiple requests for comment." Patterson stood abruptly, his mug nearly toppling from the desk. "This is ridiculous. Why on earth would the Chief Justice of the Supreme Court be in my courtroom without so much as an introduction? If that was her, she had no business sneaking in like some spy." His secretary opened her mouth to respond, but couldn't find the words. Patterson began pacing, color rising in his cheeks. "Don't they understand protocol? If a Supreme Court justice is in my courtroom, they should announce themselves, not sit in the back like a... He searched for the right word, eventually giving up in frustration. "I won't stand for this. It's a setup. She's trying to find something to hold against me." "Judge," his secretary said gently, "we need a statement. Shall I draft something or forward them to the district's public information officer?" Patterson pointed a finger. "Yes, say that we have no knowledge of the Chief Justice's presence, and that any confrontation was strictly about preserving decorum. She was an unknown spectator. That's all." His secretary nodded and backed out. Once she left, Patterson slumped into his chair, overwhelmed by a mixture of indignation and fear. He knew the judiciary was a small world. Word traveled fast, and it was never good for a district judge to be on the bad side of the Supreme Court, especially the Chief Justice. He had spent decades cultivating respect, or at least fear, in Washington's legal circles. He wasn't about to let it get tarnished by a single misunderstanding. Yet somewhere deep in his mind, a dark worry took root. Had he really insulted the new Chief Justice in front of half a dozen witnesses? The memory of his own words, dripping with condescension, repeated in his ears. "Look at you, so sure of yourself." Anger flared again. Why hadn't she just introduced herself? If she wanted courtesy, she should have followed protocol. As the day wore on, Patterson tried to bury himself in other cases, but his hands shook with each new phone call that came in. The local bar association wanted clarification. colleagues from neighboring districts asked, "Ron, is it true you threw the Chief Justice out of your court?" He denied any wrongdoing in each conversation, claiming it was a misunderstanding. Yet the more he denied, the more cornered he felt. And the more cornered he felt, the more his resentment toward Althea Sinclair grew. In the days that followed, the rumor became national news. Major outlets picked it up. Veteran district judge confronts new Chief Justice. Did bias rear its ugly head in federal court? Supreme Court's Sinclair faces disrespect on the bench. Predictably, the coverage outraged some and amused others. Pundits on talk shows debated whether Patterson's behavior was sexist, racist, or merely a crusty older judge's attempt at controlling his courtroom. Althea tried her best to remain above the fray, attending her official responsibilities and carefully avoiding sensational interviews, but she could feel the tension reverberating in every corridor of the Supreme Court. She'd catch sideways glances from staff, as if they were expecting some grand retaliation. She'd hear whispers among clerks. Is she going to sanction him? Or, I heard she might force him into retirement. Meanwhile, civil rights groups seized on the story as an example of what minority litigants faced. If a black female Chief Justice can't get respect, imagine what an ordinary black plaintiff experiences. Some activists called for Patterson's resignation, while others demanded that Althea intervene and investigate his record more thoroughly. Finally, one afternoon, Althea's phone rang with a message from the Judicial Conference's administrative office. Judge Patterson was requesting a private meeting with her, to apologize, perhaps, or to clarify the air. The meeting, they said, would be scheduled in a neutral location, and it was entirely up to her whether she would grant it. After some thought, she agreed. She wanted to see if Patterson was willing to reflect on his behavior. In the lead-up to that meeting, Althea's staff insisted she prepare for a confrontation. He might be combative, Ms. DeLeon warned. He might try to back you into a corner. Althea gave her a reassuring nod. I've faced adversity all my life. I think I can handle a judge with a bruised ego. Still, a strange sense of anticipation washed over her. She remembered the look on Patterson's face the day he singled her out in court. It had been twisted with a certain arrogance, but also something akin to fear or bewilderment that a black woman could dare stand confidently in his domain. They chose a small conference room in a side wing of the Prettyman courthouse, fittingly neutral, away from both Patterson's chambers and any public areas. Security was discreet. Only a handful of staffers knew the exact time and place to avoid turning it into a spectacle. Althea arrived first, wearing a navy blue skirt suit, her posture serene. She set her folio on the table and gazed out a narrow window overlooking the courthouse's courtyard. She wondered how many other black women had navigated these halls, quietly pushing forward justice in an environment not always welcoming. The door opened. Judge Patterson stepped in, accompanied by a district court administrator who served as a mediator of sorts. Patterson was in his usual black robe, though he'd undone a couple of the front hooks in an uncharacteristic display of disarray. His face seemed weary, with dark circles under his eyes. Althea turned and offered a measured nod. "Good afternoon, Judge Patterson." He paused, seemingly taken aback by her calm demeanor. "Chief Justice Sinclair." He didn't quite meet her gaze. "Thank you for agreeing to meet." The administrator cleared his throat. "Shall we sit?" They all took seats around a modest wooden table. Patterson exhaled, rubbing his temples. "Let me first say, I didn't know who you were. If I did, I would have addressed you differently." Althea's gaze was steady. "I understand you didn't know. But the question is, why did you address me like that in the first place? Regardless of who I am, I was a peaceful observer." A flash of defensiveness crossed Patterson's face. "I maintain order in my courtroom. I've seen too many people come in, stirring up trouble, interfering with proceedings. Have you singled out other observers who took notes?" Althea's voice was calm, but her question cut through his excuse. Patterson faltered. Not typically, no. But something about the way you were so self-assured, the way you looked at me, it felt disrespectful. Althea raised an eyebrow. Disrespectful to look at the presiding judge. You gave me no instruction that note-taking was prohibited. You only confronted me after the session ended, as if I'd violated some unspoken rule about who belongs in your courtroom. Silence hung in the air. The mediator shifted uncomfortably, glancing between them. Patterson cleared his throat. Look, I'm not proud of the tone I took, but I've always run a tight ship. And yes, I might have been on edge, seeing as it was a high-profile case. A high-profile case involving allegations of racial discrimination. Althea cut in quietly. He nodded, squaring his shoulders. Yes, and I've been hammered by the press, as though I'm some bigot who ignores real evidence. I've read the law, Chief Justice. Without direct proof of discriminatory intent, you can't convict an entire county of wrongdoing. Althea leaned forward slightly. I'm well aware of the standard for proving discrimination, but I'm also aware that the Supreme Court and numerous lower courts have recognized disparate impact and patterns of discrimination as valid considerations. Judge Patterson, the entire purpose of my presence was to see how these cases are handled on the ground. I wasn't there to entrap you. He looked at the table, clasping and unclasping his hands. So you say. He paused, then drew in a breath. If you must know, I've been advised to apologize publicly, but I don't want that. I don't want to inflame this fiasco further, and I don't believe I was entirely in the wrong. Althea studied him. What do you believe you owe the litigants in that case? They came to your court seeking justice, but from my observation, they received skepticism at best and contempt at worst. He bristled. Those claims were not well substantiated. If they had real evidence, some official directive, maybe I'd be more sympathetic. But this is the pattern these groups always push. Everything's racist. Everything's designed to keep them down. It's not that I don't care about fairness, it's just... He stopped himself, sensing he'd said too much. Althea's expression grew grave. Judge Patterson, I've spent my career ensuring the Constitution's promise extends to all Americans. You're correct that direct evidence of racist intent is rare these days. That's why the courts must be vigilant about patterns and impacts. If you can't see that, then we have a fundamental difference in judicial philosophy. He leaned back, crossing his arms. The mediator tried to break the tension. Maybe we can focus on a path forward. The case is concluded, but the concerns remain. Patterson shrugged, his tone firm. I stand by my ruling. The matter can be appealed if they disagree. I don't see what else there is to say. As for the confrontation, I'll issue a statement expressing regret for any misunderstanding. Beyond that, I have no intention of letting the press or public humiliate me further. Althea nodded slowly. Understood. So you'll remain publicly unapologetic for the way you treated me, if I may interpret your stance. He shifted uncomfortably. I said I'll regret the misunderstanding. That's all. A long silence followed. Eventually, Althea rose. Then I suppose we've said what needs saying. Thank you for your time, Judge Patterson. He stood too, avoiding her eyes, muttering a stiff goodbye. As she left the conference room, Althea felt a wave of sadness. Patterson was a man deeply entrenched in his ways. An apology from him, even if forced, would be purely cosmetic. The real issue was the underlying disregard for the experiences of marginalized communities. Walking down the corridor, she steeled herself. She had tried civility. She had tried an honest conversation. Patterson's mind seemed fixed. The next steps would require more than conversation. And so, the seeds of a more decisive response began to form in her thoughts. Within the following weeks, Althea directed her clerks and aides to quietly gather data on Judge Patterson's rulings, focusing on civil rights and discrimination cases over the past decade. She wanted to see if Patterson's approach in the voter suppression case was part of a pattern. This was unusual. The Chief Justice typically didn't investigate a single district judge's record unless there were substantial ethics complaints. But Althea believed it was worth knowing if Patterson's biases had potentially stifled justice in multiple matters. Her staff discreetly reviewed court transcripts, comparing Patterson's language in race-related cases to those in more general cases. They interviewed attorneys, many of whom, off the record, described Patterson as stubbornly skeptical of civil rights claims. Over and over they heard stories, Patterson dismissing or limiting evidence of discrimination, demanding impossibly high burdens of proof for plaintiffs, and at times speaking caustically to litigants of color. Eventually, the data painted a disturbing picture. Patterson's dismissals aligned predominantly with cases involving racial or ethnic discrimination. His acceptance of circumstantial evidence in other lawsuits, like contract disputes or business negligence, was far more lenient. Yet in cases related to civil rights, he demanded near impossible standards. Additionally, his personal rhetoric from the bench, as recorded in transcripts, often featured language belittling or questioning the motives of minority plaintiffs. With these findings, Althea was faced with a moral dilemma. Should she simply let appeals handle it? Or did she, as head of the judiciary, have a broader responsibility to ensure fairness at every level? The Constitution gave her limited powers over district judges, but she could open a path to a judicial misconduct inquiry. That, however, was a drastic measure and rarely initiated by a Chief Justice. But as news broke that yet another minority plaintiff had come forward complaining of Patterson's harsh handling, Althea felt the nudge of inevitability. Something had to be done. The Constitution guaranteed equal protection under the law, and Patterson's record threatened that guarantee. Just when tension reached a fever pitch, a strange development occurred. The voter suppression case, labeled Carter v. Appling County, took an unexpected turn at the appellate level. The 11th Circuit Court of Appeals reviewed Patterson's decision, particularly his summary judgment, and found that he had erred by ignoring the cumulative evidence of racial impact. The appellate panel reversed his ruling and remanded the case for further proceedings. In their opinion, they specifically cited Patterson's handling of witnesses, which they described as unduly dismissive, along with a failure to account for established precedent on disparate impact. The language was stern, almost scathing, and it hinted that the plaintiff's claims might indeed hold merit if properly considered. The appellate decision sent shockwaves through the legal community. Patterson was publicly rebuked, something that rarely happens so forcefully. It was a professional humiliation, a condemnation of his judicial approach. The media pounced, proclaiming it a major victory for voting rights and a reproach of biased judicial practice. When Patterson read the appellate opinion, he felt his stomach churn. His legacy was tarnished. And the worst part was the knowledge that his confrontation with Althea Sinclair had drawn extra scrutiny to his method. He tried telling himself that he'd simply miscalculated the law, that it was an honest mistake. But deep down, a flicker of guilt gnawed at him. Perhaps he had allowed his biases to overshadow fairness. In the midst of this personal and professional storm, Patterson retreated to his home in Georgetown, often skipping social functions. He rarely ventured out except to preside over his remaining cases. Each day, the hush of his near-empty chambers reminded him of his growing isolation. Even some of his longtime clerks had quietly requested transfers, unwilling to be stained by association. One afternoon he found a plain envelope on his desk. Opening it, he recognized the court stationery of the Judicial Council. The letter began, "We write to inform you of the initiation of a formal inquiry regarding allegations of biased conduct." A headache pounded at his temples. His mouth went dry. This was the formal process he had dreaded. "Karma," a bitter voice in his head whispered. He thought of how smug he had felt, calling out that black woman in the back of his courtroom, never guessing she was the Chief Justice. The memory burned like acid. That single moment, that single misstep, had unleashed a chain reaction, culminating in a public ordeal he could never have foreseen. Weeks passed as the preliminary inquiry proceeded. Testimony from attorneys across various cases painted a consistent picture. Patterson seemed predisposed to disbelieve minority plaintiffs, imposing evidentiary burdens beyond the norm. Some attorneys recounted stinging comments he'd made on the record, casting doubt on the sincerity of civil rights claims. The inquiry committee interviewed Patterson, who defended his record, but struggled to justify certain statements that, out of context, sounded deeply problematic. At length, the Judicial Council issued a report. It concluded that Patterson had, at minimum, exhibited a pattern of callous disregard for claims of racial discrimination, which threatened the appearance of impartial justice. They recommended a public reprimand, a rare disciplinary measure for a federal judge. Additionally, they suggested Patterson attend continued education on civil rights law, something that outraged him initially. But the more pragmatic side of him recognized it might be his only path to salvaging what remained of his career. The day the council's decision became public, Althea sat in her Supreme Court office, reading the statement on her tablet. She felt no jubilation. She took no pleasure in a colleague's downfall. However, she did feel a measure of relief that the system had responded. Perhaps this would serve as a wake-up call, not just for Patterson, but for other judges who quietly harbored biases. When a reporter caught Althea leaving the Supreme Court building, shoving a microphone in her face to ask if she supported the council's findings, she answered with dignified brevity, "I have great faith in the Judicial Council's process. My hope is that justice continues to guide every decision in our courts, and that all litigants, regardless of race, can be heard fairly." Judge Patterson faced a crossroads. He could fight the council's recommendation, risking a protracted battle and even harsher repercussions, or he could accept the reprimand and commit to adjusting his judicial approach. Torn between pride and reason, he wrestled with the decision. A part of him raged at the notion that he had to re-educate himself on civil rights issues. Another part wondered if maybe he'd become too rigid, too ensnared by his own biases. Late one night, he found himself sifting through old photo albums in his study. He stumbled on a faded picture of himself as a newly appointed district judge, standing with his family on the steps of the courthouse. There had been a sense of promise then, an idealistic drive to uphold the Constitution. Where had that gone? Over the years he'd become hardened, dismissive of the ever-evolving nature of discrimination. He stared at the younger version of himself. "What happened?" he whispered into the silence of his living room. In the morning, he phoned the Judicial Council's representative. He would accept the reprimand. He would attend the educational sessions on civil rights jurisprudence. He would, at least outwardly, demonstrate willingness to learn. Behind closed doors, he wasn't sure if genuine change would follow, but the first steps had been taken, and as part of the arrangement, he also agreed to a formal apology to Chief Justice Sinclair, not because he was forced, but because it was the right thing to do. One crisp morning, Althea arrived at her Supreme Court chambers to find a sealed envelope waiting. She recognized the letterhead of Judge Patterson's office. Steeling herself, she opened it, unsure what to expect. "Chief Justice Sinclair, I write to express my regret for the manner in which I addressed you in my courtroom. At the time, I did not know your identity, but upon reflection, that is irrelevant. It was never appropriate for me to single you out or question your presence. I acknowledge that my tone was disrespectful. Over my years on the bench, I have prided myself on strict adherence to the law. However, recent events have highlighted that my demeanor and rulings in cases involving claims of discrimination may have been unduly dismissive. While I cannot change the past, I commit to improving my understanding of civil rights issues and applying the law with impartiality. Your visit and the subsequent events have served as a wake-up call. I hope you can accept this apology and trust that I will endeavor to serve the principles of justice with greater awareness moving forward. Respectfully, Ronald B. Patterson. Althea exhaled, folding the letter carefully. She felt a mix of emotions. Gratitude that he had recognized his error, sadness that it took public scandal to prompt this, and a cautious optimism that maybe the system could learn and move forward. She penned a short reply, acknowledging his apology and encouraging him in his journey toward a more expansive perspective. While she didn't expect an instant transformation, she believed in the incremental power of reckoning and redemption. Over time, the memory of that fiery confrontation in courtroom 6B receded into legal lore, told among clerks and law students as a cautionary tale of underestimating someone's worth based on appearances. Yet the lessons endured. Karma had indeed struck back, forcing Patterson to face the consequences of his bias. And from the ashes of that humiliating moment, a more self-aware judge emerged, proving that even those entrenched in their ways could still learn. And there we have it, a story of misjudgment, comeuppance, and the long road toward redemption. In the grand arena of justice, one moment of prejudice can unravel a lifetime of reputation, only to set the stage for deeper self-reflection and ultimately transformation. Judge Patterson, once so certain of his authority, found himself humbled by the very system he served, and by the quiet dignity of the new Chief Justice he had so harshly dismissed. But the heart of this tale goes beyond a single confrontation. It reminds us that the promise of justice demands vigilance, courage, and a willingness to confront our own blind spots. Institutions are made of people, and people carry biases. Only by recognizing them, truly recognizing them, can we ever hope to move closer to the ideal of equal justice for all. Now, I invite you to reflect on what you've heard. If you believe in the power of accountability and redemption, if you think the law should be a beacon of fairness rather than a fortress of exclusion, then let's continue this conversation. Like this video, subscribe to the channel, and share this story with friends who need reminding that no one is above the principles of justice and no one is beneath its protection. Our dialogue can spark awareness and inspire change, one discussion at a time. Thank you for listening. Let's keep championing the cause of true justice together.